Good morning. Most of the students at UVU were not around when the Religious Freedom Restoration Act was adopted back in 1993. So to kind of explain why we're here, I think it's necessary to look back a little bit at that era for those of us who, lived through it and have a little bit of gray hair to show for that. Now, this legislation, the Religious Freedom Restoration Act, essentially says if you have a government law or policy that substantially impairs somebody's free exercise of religion, then the government has an obligation to show that it has used the least restrictive means in imposing that policy to minimize how it might impair religious freedom. That's the essence of this statute, which is now 25 years old. And it is law, remaining law, on the federal level, although the U.S. Supreme Court, as Dr. Smith mentioned, has said, now this does not restrict the states. Congress only had the power to restrict federal policy, which is why some 21 states have adopted state-level versions of this. Now, why was this done? Back in the 90s, we had several things that have been going on that concerned people. On the Religious Freedom Restoration Act, there was a particular court decision. The facts of it really don't matter, but it concerned people that the courts were going to use a very broad interpretation that would allow government policy to impair the free exercise of religion. Therefore, this law saying you got to use the least restrictive method possible. And it has to be a law that's general application. It cannot be aimed at religion. But it wasn't the only thing going on. We had what had happened with the courts in Hawaii and later in Vermont, basically beginning the policy of courts saying there is a constitutional right to same-sex marriage. So in this same general era, Congress adopted the Defense of Marriage Act, DOMA, which said for purposes of federal law, marriage is only between a man and a woman. Now, if states want a state law that differs from that, they can make it effective only in their own state boundaries, but they cannot, that's not going to be entitled to require other states to give some sort of recognition or full faith and credit to that. And then the third thing that was going on that era, which I was most involved with personally, there'd been a whole series of cases, basically known as the school prayer cases, that were restricting what could be done in school settings, or for that matter, on other parts of public property that involved prayer or other religious expression. So we had all these things that were going on in that era. Now, today, the culture has changed very much since then. This Religious Freedom Restoration Act, which was unanimous by voice vote in the House and had only 3 nay votes in the Senate, would have a very difficult time getting passed today because the culture has changed. We've had several tipping points in that. And the notions of religious freedom have been narrowed in this, which is a fascinating thing. I mean, just take for a moment, let's analogize with the school prayer cases. Normally speaking, when you are on public property instead of private property, your rights normally are broadened because you don't have a private property owner just say, you are limited in what you can do on my property. However, when it comes to religion, the fact that you're present on public property is used to minimize what your rights are. In some of the school prayer cases, Supreme Court Justice Potter Stewart said that if you have a law that requires a student to go to school, and while they're there, they're required to abstain from what is normally religious expression anyplace else, then you've placed religion at an artificial and state-created disadvantage. Former Chief Justice William Rehnquist, in a dissent in one of those cases, Wallace versus Jaffrey, said, courts quit using this phrase, separation of church and state. It's not in the Constitution. And in Justice Rehnquist's words, it causes a mischievous diversion from what the First Amendment actually says and what the Founding Fathers were actually doing. Now, think about that. If the requirement is a total separation of church and state, then as government expands and takes up more space in our lives, religion is required to shrink. The Constitution doesn't say anything about separating them. But these are the underlying philosophies. So, as the different efforts were made back in the 1990s, the Defense of Marriage Act, which has now been struck down by the U.S. Supreme Court, the Religious Freedom Restoration Act, which has been limited by the Supreme Court to policy, but not there. And my own effort was the Religious Freedom Amendment, which sought to address a number of things. But here's the catch. When we talk about restrictions that are being imposed or culture changes, we have decisions from courts that say this is dictated by our interpretation of the Constitution, even if that interpretation may be backed up only by a 5-4 decision on the U.S. Supreme Court. So this has constitutional standing. But when we say these solutions are going to be based upon just statutes, which can themselves be declared unconstitutional, you have a disparity between what the nature of the problem is elevated to a constitutional level and the solutions are down here on a statutory level, which are inferior, because the Constitution is going to trump any statute. This has been going on for many years, with the culture changing. And ironically, when the Religious Freedom Restoration Act was adopted, it was trying to get ahead of what they thought would be a series of court decisions. Today, threats to free exercise of religion are much greater than they were in 1993. And that demonstrates to me that more than ever, we need the Religious Freedom Restoration Act, as well as attention to other religious freedoms. Would you hand me my water for a moment, please? Thank you. Now, this has come about by creating a conflict between two important concepts of rights: religious freedom and sexual freedom. Because the mechanisms used to try to attack or limit the Religious Freedom Restoration Act are saying, oh, wait a minute, you cannot use this to limit findings on same-sex marriage or LGBTQ rights and so forth. And the people who have fallen off the bandwagon for the Religious Freedom Restoration Act, if you read what they say as to why, it's because we believe we have to respect constitutional rights of same-sex movement, which are more important than religious rights. But it not only is a question of sexual freedom versus religious freedom, it also becomes a question of rule of law. We have an explicit constitutional provision in the First Amendment not to interfere with the free exercise of religion. We do not have anything mentioned in the Constitution regarding sexual behavior. But we have different Supreme Court decisions that relate to that, obviously with abortion laws and with same-sex marriage and so forth. But the claim is being presented today that the rights that we believe are inherent rights that are not mentioned in the Constitution get priority over rights that are mentioned in the Constitution. Now, our Constitution does not claim that all possible rights are expressed in the Constitution. That's in the Bill of Rights, back in the Ninth Amendment in particular, and the 10th Amendment too, plus in the Declaration of Independence, where Thomas Jefferson wrote, all men are created equal, endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness. And the Founding Fathers believed that rights did not come from government, they came from God. And whether government gives you a right or not doesn't mean you don't have it. So are the ones which courts find to be inherent superior to those that we have made explicit. That is why the concept of rule of law is at issue in this challenge that people face. If we are going to say that things that are explicit in the Constitution can be overcome by something that courts decide exist and have a higher priority than the ones that we have already agreed upon and enshrined in the Constitution, that judge-made law is superior to the written Constitution, that becomes a threat to rule of law itself. And furthermore, if you look at what's happening, because as the culture changed, many of the people and organizations who originally supported the Religious Freedom Restoration Act, which was adopted almost unanimously, are now saying very different things. For example, the principal author of the legislation in the House of Representatives was then Congressman, now U.S. Senator Chuck Schumer, who is the Democrat leader in the U.S. Senate today. Now, after the Hobby Lobby case, where the Supreme Court, on the basis of RFRA, said that a closely held corporation, which was doing business as a subchapter S, not publicly traded, but closely held corporation, is still identified with the individuals and they retain their religious rights, and the Religious Freedom Restoration Act means that government cannot interfere with that and require them to do contraceptive means or abortifacients that are contrary to their religion, because it's a closely held family business, no matter how big it is. It just involves a handful of owners. Well, after that came out, Senator Schumer condemned the case. And just to share with you some of his words in supporting the legislation to undo now RFRA, he basically said that people have to choose between exercising their religious rights and doing business. As Senator Schumer said, we wouldn't tell the owners of Hobby Lobby to convert to a different religion or disobey their religion, but we don't say that they have to open up a company and go sell toys or hobby kits. That you have to surrender certain other rights if you insist on exercising your religious rights. And indeed, if you read the briefs that were filed by the Solicitor General on behalf of the Obama administration in the Hobby Lobby case, you will find that the contention made by the government was, whenever somebody is engaged in making a profit, they must surrender some of their constitutional rights, and specifically First Amendment rights. That if you want to be engaged in profit-making activities, you must surrender First Amendment rights. That's in their briefs. Now just extrapolate that, not only on religious freedom, but I think most of the, even though they sometimes fail to do it, most of the major media news outlets are designed to be profit-making. Does that mean they have to surrender their right of free speech or freedom of the press because they're trying to make a profit? And the profit motive taints constitutional rights. That's the contention that not only was in the briefs from the Solicitor General in the Obama administration, but is being pushed by many other groups today. You know, if you do not do the things that we want, we're going to drive you out of business. And certainly there are cases before the U.S. Supreme Court right now that relate to that. So it's not just an attack on the free exercise of religion. It's an attack upon the rule of law. It's an attack upon someone trying to make a living or to actually be an entrepreneur as opposed to just an employee. That's how broad the attack is. And that's how much it's gotten the field. And the rhetoric You read things, for example, like from the ACLU, which originally supported the Religious Freedom Restoration Act, and now they say, oh, this is being used as an excuse to harm people in the same-sex community or in others who might be discriminated against. And the legislation that is currently pending, and it's been filed in many different forms, but the one currently pending is called the Do No Harm Act. Joe Kennedy being the principal sponsor of that, with some, I think it's 118 co-sponsors who all happen to be Democrats. There are no Republicans that are co-sponsors on the H.R. 3222, Do No Harm Act. And it says in its provisions that everything in the Religious Freedom Restoration Act that requires government to use the least restrictive means for anything that might interfere with freedom of religion, but it doesn't count if it involves the Civil Rights Act of 1964, the Americans with Disabilities Act, the Family Medical Leave Act, Executive Order 11246, the Violence Against Women Act, the Department of Housing and Urban Developers rules entitled Equal Access to Housing and HUD programs regardless of sexual orientation or gender identity, and the religious protection provisions also don't apply if it involves employers providing wages, other compensation or benefits. Does not apply if it involves collective activity in the workplace, or protection against child labor, abuse, or exploitation, or access to information about, referrals for, provision of, or coverage for any health care item or service. And it goes on with a couple more ways, and they want to create so many carved out exceptions to say that government can interfere broadly with the free exercise of religion. And again, it's not exclusively so, but it typically has been framed as a debate between religious freedom and sexual freedom. Now, there's no need to have that particular conflict unless you are intolerant of someone who disagrees with you. And that's what's being framed. This is the situation as I see it. It involves the cultural changes that are dramatically different from what the culture was in the United States in 1993. We've had a lot of tipping points that have happened in my lifetime. Go back to the 1960s with assassinations of a president and other people, a lot of civic unrest, campus unrest, riots in different places. We've had the growth of mass media, which allowed the culture which the media promoted to displace opposing values. And certainly we've had a growth in judicial activism and a tepid response from a lot of lawmakers. Rather than saying a constitutional declaration or abuse by a court requires a constitutional response, whether it be elevating the proposed remedy to a constitutional amendment or using the ability to impeach judges. Most impeachments in American history have been of judges, not of any other office holders. But lawmakers have been behind the curve, and unless you take a constitutional level response, which is certainly what I chose to do with the Religious Freedom Act, which was voted on in the House in 1998. It got a majority vote, but not the requisite 2/3. But unless people who are in positions of responsibility make a response that's commensurate with the level on which opponents are acting, enshrining certain things beyond the reach of the public, beyond the reach of normal legislation, by saying this is a constitutional mandate and therefore you cannot touch it. That's the challenge that we deal with. I hope that's helpful to you to have some understanding and perspective of what we're dealing with. And it boils down to the question, what manner of people do we want to be? And do we want an orderly system of governance which allows the people to be sovereign, not any group of elites, whether they be a president, a senator, a Supreme Court justice, or anyone else. It boils down to our ability to govern ourselves. Thank you.